Okay, so thank you all for joining us. Just to introduce ourselves briefly, I'm Amy Ertan. I'm a cybersecurity researcher at Royal Holloway, University of London, where I'm pursuing my PhD. And this research was the output of a data protection fellowship done at the Institute for Technology and Society of Rio de Janeiro, where I met Christian and the team. And this is an international data protection initiative, this program that's sponsored by the UK Foreign Office. Christian, over to you.
Thank you, Amy. I'm very excited to talk to you about this very interesting topic today. As Amy mentioned, I'm Christian Perrone. I am a researcher at the Institute for Technology and Society of Rio de Janeiro, ITS Rio for short. My areas of expertise are regulation and technology, particularly emphasis on international law. I had a little bit of an international background as well, work in international organizations. So this is very fitting for our two topics today, which blend international trade agreements and international personal data transfers. Amy and I have identified two windows of opportunity to blend those two topics. But before we enter those two windows of opportunity, we just wanted to say that in the beginning, we'll have a very high-level presentation on a few of the background topics so that we are all in the same page discussing that. So can you talk a little bit about the EU for us, Amy, and our
Absolutely.
first window of opportunity?
Yeah, so last year, the output of 20 years of negotiation, we had the largest global trade agreement between Brazil, the European Union, and Mercosur. So this trade deal, it was seen as a huge opportunity in terms of potential trade for Brazil, and also for us, and as Victor mentioned, an opportunity on data transfer or on digital trade and e-commerce trade. So data protection became quite a key concept for us for this in terms of facilitating that trade and transfer of digital items. So Christian will introduce some of the context around Mercosur now.
Just wanted to say a few words, just that Mercosur is a trade bloc in the South America, particularly involving Argentina, Brazil, Paraguay, Uruguay, and Venezuela. Just a small note, Venezuela now is suspended due to application of the undemocratic clause. We can discuss it more in Q&A, but it's not as important to our discussion today than it is that all the other four countries are very keen on this trade agreement, and they are discussing all of them on data protection legislation, and two of them already have it, and Brazil just approved in 2018, and Paraguay is also discussing that. Can you talk a little bit about data protection now? Oh, before we go there, there's a second window of opportunity as well that happened in the beginning of this year when in Davos, the Ministry of Economy of Brazil, Paulo Guedes, met with high-level officials of the UK, and they stated that even if the UK leaves the EU, there will be an opportunity, and they're very keen on having a trade agreement either with Brazil or Mercosur. So this is the second window of opportunity as well. We might discuss it as well. So talk about data protection in the EU very briefly, Amy. Thank you.
Yes, absolutely. So I'm sure many of you are intimately familiar with the general data protection regulations, the European Union legislation on personal data. So protecting and introducing legislation around the collection, processing, and storage of personal data. And of course, as an extension of that, specifying conditions for the transfer of personal data. Of course, this applies to the European Union and those wishing to trade with them, but there are similar legislative efforts happening across the world. And Christian will take us through the version.
Indeed, Amy. People even say that Brazilian legislation that was approved in 2018 in Portuguese, Lei Geral de Proteção de Dados, or General Data Protection legislation, is basically a GDPR, a Brazilian GDPR, or GDPR à la mode Brazilian. So it's certainly very similar. If you look at even the topography of the legislation is very, very much similar. But even more than that, the structure, the logic, and the values behind the data protection scheme that was put in place by the Brazilian data protection legislation, it's very, very similar to the European standards. Just a small note, this law is not yet into force. There's big discussion on when is it going to enter into force. We can discuss that later as well if you want it in the Q&A, but it's sufficient to say that it's supposed to enter into force in 16th August 2020, or so this year. And it was approved last week that the administrative sanctions will enter into force only on August next year, but still has to be approved by the Senate, and President might veto that as well. But how we connect international trade agreements and data protection? Why is it important to have a discussion on international data transfers within the context of international trade? So it is important to think that in most transactions, international transactions, particularly international trade, will have, even if it's a small component, but we'll have a component of personal data being transferred overseas, which means that, for instance, at least the name of a person in a contract will have to be transferred, and that is personal data. And that might imply some hindrances and some obstacles to have this transfer going through on a valid legal basis. And that's particularly true for the EU and Brazil, just because the logic behind the legislation is that not only activities that happen within the territory of those of Brazil or the countries within the EU are regulated by their own data protection legislation, but also other activities that extend beyond the geographical scope of those legislations or those countries involved are also encompassing. This is sort of having a privacy bubble encompassing personal data going beyond or crossing the borders, crossing the frontiers of the countries. It doesn't have to be the same protection. They have to be met, but at least similar and adequate standards of protection in order for the transfer to occur. So it means that for international trade, whenever you have to transfer personal data, they have to meet some conditions that can be prior or negotiated during the transaction itself. Just to have an idea how similar these two legislations actually are, we can look at Article 3 of GDPR and Article 3 of LGPD. So not common Article 3 of the Geneva Convention, but very common Article 3 as well. They have a very similar scope or similar cases where the application of the legislation goes beyond the geographical territory. I just want to call attention a little bit for the second part of it, which relates to offers of goods and services that target or are directed to people in countries in the Union, the European Union, or target people in Brazil. So for instance, if you go to a website, and this website, even though it might be for a foreign company, it might be through foreign servers, or may be managed by foreign nationals, there'll be the data protection aspects will be encompassed and applicable whenever this website, for instance, changes automatically legislation to Portuguese, or whenever it has the currency in Brazilian, whenever it's actually targeting people inside Brazil or targeting people in the EU. But so this could potentially be a hindrance to free flow or international trade transaction. But when can we have this international transfers of personal data? Can you tell us a little bit about that, Amy?
Sure. So taking almost a slight step back to look at models of international data transfer, you have broadly three buckets we can talk about. So the first bucket, the first category would be the free flow of personal data. So actually you can just transfer it. There aren't those conditions. And in practice, no country has this model in practice in a pure form. You can perhaps look at the kind of the US domestic environment where you have sectoral legislation. Hamdan, I think I might need you to mute yourself. So you have within the US sectoral legislation. So where there is something that is not covered, there are gaps in that legislation, you have this free flow there. Now, the second bullet point, the second category, is almost like a Canadian model. So it's an obligation-based model where you agree contractual clauses between those you want to. 1 second. There we go. Now, where you want to agree bilateral contracts between those you wish to transfer data with. So potentially quite a few agreements, quite a high burden. The third category is the hybrid model. So this is the model which both the European Union and Brazil have adopted, where you have this concept of adequate countries, like a circle or a group of countries that have agreed to maintain the same standards of protection, and then outside that circle you have you have free flow within that, and then outside you have the second bucket, in which case there are conditions to be met. And in terms of this concept of adequate countries, Christian will go into a bit more about what that means and what that guarantee means.
Indeed, as Amy has already stated for us, there is a circle of countries that we might be considered to meet the standards of protection necessary in order to have a somewhat free flow of personal data. So it would be akin to have a very easier burden on international trade. But when we look a little bit further on what has happened in the EU, which countries are considered adequate, has a decision of adequacy and by the European Commission, you look at only 13 countries are there. But more importantly, if you look out of the 13 countries, you look at 2 of them are members of Mercosur. You can look at Argentina and Uruguay. So it's a strong case that since Brazil has a very similar piece of legislation, that the GDPR, that it could be a third country from Mercosur to be a part and receive adequacy decision. But if you look again, you can look at that some of those countries actually, before they are considered adequate, they had to participate in a procedure or a process of negotiation with the EU, establishing an agreement, data protection agreement, in order to pave the way for this adequacy decision. If you look at the United States with the Privacy Shield, you see that it is sort of an important way for enterprises in the US that meet certain standards that are agreed to higher their level, to be very similar to the GDPR standard or adequate levels of data protection, to be able to circulate freely data from Europe to the US and vice versa. If you look at Japan as well, there were years of negotiation in order for Japan to be considered adequate. And if you look at South Korea, since at least in 2017 that they were negotiated, not yet achieved this agreement on data protection, how it would be in order to pave the way for a decision. So there is still somewhat a path that Brazil should follow. So it is somewhat a case that Brazil may have because of all the daughter countries in the region that already have achieved the same status. But there are still some conditions that Brazil might have to meet. And those conditions go beyond the regulation itself. Isn't it, Amy? Can you talk a little bit about the conditions that might come up?
Absolutely. So this is where I put my cybersecurity hat back on. So aside from the regulatory analysis, you also need to pay some attention towards the very pragmatic aspects of actually transferring the data securely and ensuring kind of the golden triad, as we call it, of confidentiality, availability, and integrity of the data. So this refers to the fact that in order to be able to, well, very likely, in order to be able to meet adequacy conditions, you have to demonstrate that you are employing and maintaining good cybersecurity hygiene. So whether that's keeping your data safe and encrypted, keeping personal data secure backups, data efficiency, and kind of other more general things like firewalls, antivirus, and so on. To try and reduce the frequency of some of these stories we can see on the left-hand side of this screen. Now, from our research into the cybersecurity kind of adherence across Brazil, that there is quite a large gap that needs to be closed when we look at kind of meeting those thresholds. Of course, the burden is probably lightest on the largest corporations, those who already transfer data internationally, so may well have had to comply to GDPR type regulation or similar regulations. But this is really the minority of corporates and companies across Brazil. So quite a large awareness raising effort is going to be required there in order to start making sure you can adhere to the conditions as part of these legislative efforts.
So Amy and I, we actually focus on cybersecurity, but actually information security in general, because the GDPR and LGBT is actually go beyond the cyber domain. But it's very important that we take into consideration that the conditions go beyond basically having a regulation in place, but actually have to comply with the level and standard levels of protection that personal data requires. And just to finish up, we wanted to give some sort of to drill in two cases, so we have a very clear picture of what we have happened, particularly, as Amy mentioned, for SMEs, small and medium enterprises in Brazil that we have to comply in order to participate in the international trade of goods and services. Particularly, we wanted to have a very relatable examples so that people could actually see how even minor situations will involve personal data transfers, and it might be cumbersome for SMEs to comply with. So, sorry, we talked about two scenarios. One is Brazil as an exporter. So we talked about a company that hired a tourist agency in order to provide all the travel arrangements in order to go for their employees to go to Europe. And imagine how much difficulty would be. They would have to, this tourist agency would have to comply with either requesting specific consent from the data subject, or meaning the employees of that company, in order to transfer its data in order to comply with it, the requirements of the LGBT, or would have to have an arrangement. Particularly would be probably a contractual arrangement on standard contractual clauses on data protection privacy with all its vendors in order to safely, securely, and legally to transfer internationally. So I mean, a very cumbersome procedure, which would be very similar for when it's an importer, because the GDPR also established the same or even more stringent levels of standards to comply in order to have an international transfer to occur. So imagine as an importer, you are now the hotel in the other end of the stick, and the hotel has to comply with the standards of protection of many different countries in Europe. So they either have these agreements in place beforehand, or negotiate in between the transactions, or they have to make sure that the legal basis for the transfer from the European data to Brazil are complied with. So for instance, the consent was obtained legally and is a valid consent. So as you see, if you want to foster international trade, we'll also have to discuss international data protection or international personal data transfers as well. So we have identified there's two windows of opportunity to either discuss within the framework of these international trade agreements, or parallel to those trade agreements, to discuss international personal data agreements as well, to pave the way for reciprocal mutual adequacy decisions that would be, because both the EU and Brazil and some other countries in Mercosur might as well follow the same path, have the same practice that needs adequacy decision in order to have this tier of free flow of data in between countries that are considered adequate or have an adequate standard of protection. So if we don't have any other comments, Amy, we can open for Q&A. So Amy, tell us.
Absolutely.